Although we will legally leave the EU and cease to be a member state on March the 29th, 2019, Part 4 of the agreement provides for an implementation or transition period of 21 months. During that implementation period, it is provided that union law should continue to apply, and the laws, systems and institutions of the EU will have the same role and functions as before. The Northern Ireland Protocol and some of the other provisions of the withdrawal agreement relevant to it. The protocol would come into force, if needed, on the conclusion of the implementation period on the 31st of December 2020, unless, pursuant to Article 132 of the agreement, both the UK and the EU agree to a single extension for a fixed time of up to 1 or 2 years. Once in force, by Article 2.1 of the Protocol, the parties would be obliged in good faith to use their best endeavours to conclude, by the 31st of December 2020, an agreement that supersedes it. There is a separate but closely related duty on the parties under Article 184 to negotiate expeditiously and use best endeavours in good faith to conclude an agreement in line with the political declaration. If the protocol were to come into force, it would continue to apply in international law unless and until it was superseded by the intended subsequent agreement which achieved the stated objectives of maintaining the necessary conditions for continued North-South cooperation, avoiding a hard border, and protecting the Belfast Agreement in all its dimensions. There is, therefore, no unilateral right for either party to terminate this arrangement.
So it's a trap.
This means that if no superseding agreement can be reached within the implementation period, the protocol would be activated, and in international law would subsist even if negotiations had broken down. Under the protocol, the UK would form with the EU a single customs territory for goods for fiscal or tariff purposes. However, Northern Ireland would additionally apply defined aspects of the EU's single market rules relating to the regulation and control of the supply of electricity on the island of Ireland, goods, including cross-border VAT rules, and the EU Customs Code. These rules would be enforced as they are now, including preliminary references from Northern Ireland courts to the Court of Justice of the European Union. Turn now to the role of union law and the CJEU under the withdrawal agreement and within the dispute settlement provisions. To this end, following the implementation period, the agreement provides for the continued application of union law in defined and strictly limited respects where it is necessary or desirable for legal certainty to do so. Union law and the Court of Justice will possess a relevance in the United Kingdom only insofar as it is necessary in limited and specific areas for the winding down of the obligations of our relationship. It provides under Article 160 for union law and the jurisdiction of the court to apply beyond the implementation period only for the time and purpose of closing out the UK's financial obligations and entitlements